When married couples neglect to prepare an estate plan, state intestacy law provides one for them. It may not be the plan they would have designed, but at least it offers some measure of financial security for a surviving spouse and children. Unmarried couples, however, have no backup plan. Unless they carefully spell out how they wish to distribute their wealth, a surviving life partner may end up with nothing. Hi, I'm Antoinette Bone, estate planning, probate, guardianship, and elder law attorney in the Dallas-Fort Worth Metroplex. Today, I'm going to discuss the estate planning advantages that married couples enjoy and how unmarried couples can reduce their risks. I will also discuss one strategy in which unmarried couples have an advantage: a grantor retained income trust. Marriage has its advantages because intestacy laws offer no protection to an unmarried person who wishes to provide for his or her partner. It's essential for unmarried couples at a minimum to employ a will or living trust. But marriage offers several additional estate planning advantages that unmarried couples must plan around, such as the marital deduction. Estate planning for married couples often centers on the marital deduction, which allows one spouse to make unlimited gifts to the other spouse free of estate or gift taxes. Unmarried couples don't enjoy this advantage. Thus, lifetime gift planning is critical so they can make the most of the lifetime gift tax exemption and the permissible gifting of $15,000 per recipient annual gift tax exclusion. Unmarried couples also should pay close attention to transactions that may inadvertently trigger gift taxes, such as payment of a partner's living expenses. Married and unmarried couples alike often hold real estate or other assets as joint tenants with rights of survivorship. When one owner dies, title automatically passes to the survivor. In many non-community property states, a special form of joint ownership called tenancy by the entirety is available only to married couples. In community property states like Texas, community property is a form of ownership exclusive to married couples. In Texas, it is presumed that all property acquired during a marriage is community property. This can have significant advantages for a spouse who may not have been the primary breadwinner in the marriage. Unmarried couples do not get to benefit from this form of ownership at all. Unmarried couples who seek greater protection against creditor claims should consider placing assets in a trust. Married or not, anyone's will is subject to challenge as improperly executed or on grounds of lack of testamentary capacity, undue influence, or fraud. For some unmarried couples, however, family members may be more likely to challenge a will simply because they disapprove of the relationship. Here are steps unmarried couples should consider to reduce the risk of such challenges. 1. Be sure that the will is carefully worded and properly executed. Use separate attorneys, which can help refute charges of undue influence or fraud. Include a no contest clause which disinherits anyone who challenges the will and loses. 4, explain in the will the reasons for favoring one's partner over other relatives. And 5, use asset transfer tools that are more difficult to challenge, such as joint ownership, beneficiary designations, or trusts. A married person generally can make healthcare decisions on behalf of a spouse who has become incapacitated by illness or injury. Unmarried partners cannot do so without a written authorization, such as a medical power of attorney. A durable power of attorney for the management of financial assets may also be desirable, allowing a partner to manage the other's assets during a period of incapacity. By transferring assets to an irrevocable trust, a wealthy partner, who would be the grantor, can provide for the less wealthy partner in the form of distributions of trust income and/or principal as needed. The grantor can determine to whom the trust property will pass in the event of the death of the beneficiary or dissolution of the relationship. Finally, there is the advanced gifting strategy called the Grantor Retained Income Trust, or GRIT for short. Although married couples enjoy several estate planning advantages over their unmarried counterparts, there are a few situations in which unmarried couples have an advantage. A GRIT gives the grantor, who's typically going to be the wealthy partner, the option of transferring assets to a trust while keeping the right to receive all of the net income from the trust for a fixed term of years. The remaining trust principal is either distributed to the remainder beneficiary, in this case the less wealthy partner, or held in trust for the benefit of the less wealthy partner. By retaining income and certain other interests in the trusts, however, the grantor minimizes its value for gift tax purposes. So long as the grantor survives the trust term, a GRIT has the potential to transfer substantial amounts of wealth tax-free. Now, this led Congress in the late 1990s to eliminate these tax benefits for intra-family transfers. But unmarried couples and other non-family members can still take advantage of this powerful estate planning tool strategy. Careful planning is required if you're unmarried but wish to provide for a life partner. Be sure to consult an estate planning advisor to discuss potential strategies. You can achieve many of the same estate planning objectives as married couples, but only with careful planning and through documentation. I'm Antoinette Bone, estate planning, probate, guardianship, and elder law attorney in the Dallas-Fort Worth Metroplex. If you found this content useful and would like to see more like it, please subscribe to my page, like this video, and don't forget to tell your family and friends. Thanks for watching, and I will see you next time.